Hello everyone, welcome back to our pre-review class for the corporation law. And now for this video, this is our final session for the corporation law kasi we are now in dissolution, meaning papunta na tayo sa termination ng corporation. So yung dissolution natin, merong dalawa. We have voluntary and involuntary dissolution. No? When you say voluntary dissolution, ayan, it means that the members of the corporation or the stockholders decided to dissolve the corporation. When you say involuntary, meaning there are events or circumstances that are beyond the control of the stockholders or members, which resulted to the dissolution of the corporation. Okay? Number one, voluntary dissolution where no creditors are affected, kung walang utang, okay? Kailangan lang ng majority vote of the board of directors or trustees, majority, no? Resolution of the stockholders owning at least majority of the standing capital stock or majority of the members in the meeting called by the directors or trustees. Notice given to each stockholder or member at least 20 days prior to the meeting, which shall state the purpose of the meeting. So una, yung board, magko-call sila ng meeting para i-agenda nila yung dissolution. Kailangan makakuha sila ng majority vote of the quorum ng board of directors. And then they will refer that to the stockholders meeting. Patawag na naman sila ng stockholders meeting para mag-vote naman sila doon. Majority of the outstanding capital stock lang yung kailangan, no? Para magkaroon sila ng resolution for the dissolution. And then after that, magbigay sila ng notice, no, to each stockholder member at least 20 days, no, prior to the meeting. Notice of time, place, and object of the meeting shall be published in the newspaper of place where the principal office of the corporation is located, or if there is no newspaper, in the newspaper of general circulation. A verified request for dissolution shall be filed with the commission, stating the reason for the dissolution, the form, manner, and time when the notices were given, the names of the stockholders and directors and members and trustees who approved the dissolution, the date, place, and time of the meeting in which the vote was made, and details of publication. So, etong nakalagay dito are formal requirements, no, para paano ba mag-apply ng dissolution, ng voluntary dissolution. The corporation shall submit the following to the commission: a copy of the resolution authorizing the dissolution, certified by a majority of the board of directors, proof of publication, and favorable recommendation. Okay? Within 15 days from receipt of the verified request for dissolution, and in the absence of any withdrawal within said period, the commission shall approve the request and issue the certificate of dissolution. So the dissolution shall take effect only upon the issuance by the commission of a certificate of dissolution. So kung yung existence ng corporation is upon the issuance of a certificate of incorporation, yung dissolution naman upon the issuance of a certificate of dissolution. Paano kung merong mga creditors na affected? Okay, ano yung mga requirements? Una, same kanina, kailangan may majority vote of the board of directors. And then, ito yung difference. Kanina, kapag walang creditors, majority lang ng stockholders or members. But kung merong creditors, kailangan ng 2/3 votes ng stockholders or members. Then, hindi lang notice, no, or verified request, kundi verified petition. Okay, yung ipa-file natin. Signed by a majority of the corporation's board, verified by its president or secretary or one of its directors or trustees. Then set forth all claims and demands against it, and that its dissolution was resolved upon by the affirmative vote of the stockholders representing at least 2/3 of the outstanding capital stock or at least 2/3 of the members at a meeting of its stockholders and members called for that purpose. And ano yung reason? Form, manner, and time when the notices were given, date, place, and time of the meeting in which the vote was made. So, mag-submit din sila ng mga documents to the commission, yung copy ng resolution, countersigned by the secretary, and a list of all its creditors. So, ito yung kaibahan kanina. And again, same rule, the dissolution shall take effect only upon the issuance by the commission of a certificate of dissolution. Dissolution by shortening corporate term. Di ba? meron tayong yung pag mag-shorten kayo ng corporate term, meaning to say, kailangan mo ng 2/3 votes ng stockholders, no, outstanding capital stock. Now, let's go to involuntary dissolution. A corporation may be dissolved by the commission motu proprio, meaning pwedeng independently ng commission, pag may nakita silang grounds for dissolution, pwedeng sila mismo ang mag-dissolve. So, mag-issue lang sila ng order of dissolution or upon filing of a verified complaint by any interested party. So, dito sa involuntary dissolution, merong mga grounds tayong pag-uusapan. Okay? Number 1 is non-use of corporate charter. So, kung hindi mo ginamit yung corporate charter nyo, then the commission may dissolve, no? May order the dissolution. Then continuous in operation. Di ba remember na kailangan 5 years yata, 5 years yun na dapat naka-operate ka within 5 years, no, from the incorporation. Otherwise, you will be dissolved, no? Mag-order yung commission. Upon receipt of a lawful court order dissolving the corporation, upon finding by final judgment that the corporation procured its incorporation through fraud. So kung yung pagkuha mo ng registration is through fraudulent means, pag nalaman yon at na-prove, then pwede kang ipa-dissolve. Upon finding by final judgment that the corporation was created for the purpose of committing, concealing, or aiding the commission of securities violations, smuggling, tax evasion, money laundering, or graft and corrupt practices, committed or aided in the commission of securities violations, smuggling, tax evasion, money laundering, or graft and corrupt practices, and stockholders knew and repeatedly and knowingly tolerated the commission of graft. Ayan, di ba? Ito yung nangyari sa sa kapa, di ba? Kasi meron silang mga securities violations, etc. Mga violations under the law, no? Tax evasion, money laundering, yung mga fraud na mga ito, fraud, so pwede silang ipa-dissolve, okay? Corporate liquidation. So, kapag na-dissolve ba yung corporation, automatically nawala na yung existence niya. Gaya ng mga partnership, meron tayong winding up, no? Winding up, no, of the corporation, or tinatawag natin dito for corporations, corporate liquidation. Every corporation except banks whose charter expires pursuant to its articles of incorporation is annulled by forfeiture or whose corporate existence is terminated in any other manner shall nevertheless remain as a body corporate for 3 years after the effective date of the dissolution. Ang ibig sabihin nito, kahit na na-dissolve na yung corporation, meron ka pang 3 years para i-liquidate mo yung affairs ng corporation. Like, kung meron kang mga assets, ibenta mo. Kung may utang, bayaran mo. So, that is actually liquidation. So, 3 years ang ibibigay sa'yo ng batas, no? Or kung merong mga cases to prosecute and defend, no, suits by or against it, no, and enabling it to settle and close its affairs, no? But not for the purpose of continuing the business for which it was established. Pero hindi ka na pwedeng magbenta or mag-conduct ng business affairs. Ang kailangan mo lang sa 3 years is dapat ma-wind up mo and then ma-liquidate mo siya, mabayaran lahat ng utang, makasuhan lahat ng kasuhan, makollect lahat ng mga receivables, and then ma-distribute lahat ng mga shares, no, to the stockholders. Except by decrease of capital stock and as otherwise allowed by this code, no corporation shall distribute any of its assets or power except upon lawful dissolution and after payment of all its debts and liabilities. Okay, take note of that. The expiration of the 3-year period does not mean that the pending case will be terminated. Ang example nito, paano kung natapos na yung 3-year period, hindi pa natapos yung case? Maapektuhan ba yung case? The answer is no. It will continue. No? If full liquidation can only be effected after the 3-year period and there is no trustee, the directors may be permitted to complete the liquidation by continuing as trustees by legal implication. So, hindi ibig sabihin na kapag yung 3-year period tapos na din yung liquidation process, no? It could be na pwede siyang mag-continue, yung directors na ngayon ang magiging trustees by legal implication, okay? There is no time limit within which the liquidation should be completed in the hands of the trustees. Okay? So, ang ine-emphasize lang dito is yung 3-year period, hindi talaga siya strictly and mandatory na within that period lang mag-liquidate. Okay? Ano lang yan, reasonable time lang yan na binigay ng batas. But hindi siya ibig sabihin na pagtapos na, hindi ka na makaka-liquidate. Okay? So if there is still a pending case when the 3-year period to liquidate expired, and there is no trustee that is appointed, the council of the corporation who prosecuted and represented the interests of the corporation may be considered a trustee of said corporation with respect to same case, and he can continue to represent the corporation. Okay, thank you very much. No, that ends our discussion for the corporation law. So thank you for listening, and I hope that may natutunan kayo sa ating lectures, no? Series of videos that I have given to you, and of course, study the lessons and the topics for your upcoming drill. Thank you and goodbye.